So the next session is looking at the international framework for IDP participation in elections. First of all, wanted to start by looking at the international law obligations that there are. And as I think many of you in the room know, there is nothing explicit in international law that refers to IDP's voting participation. However, the general election obligations that Ukraine has under international law have applicability to IDPs, as of course IDPs are citizens of the country.
Пожалуйста. Да? Yeah.
So the key instrument that makes reference to electoral rights, which, as I say, applies to IDPs as much as to any other citizen in Ukraine, is in the International Covenant on Civil and Political Rights, with the Article 25 talking about every citizen having the right and opportunity, without any of the distinctions mentioned earlier, and without unreasonable restrictions, to having the right to take part in the conduct of public affairs directly or through freely chosen representatives, and to vote and to be elected at genuine periodic elections, which shall be by universal and equal suffrage and shall be held by secret ballot, guaranteeing the free expression of the will of the electors. In this, I just wanted to emphasize a few words. First of all, it talks about citizen rights, so it's not for everybody. This right is limited to citizens of a country. And also it talks about the right and the opportunity. So this isn't just about having legal provision saying that people can vote. It's about actually being given the chance to do that. So it's about what actually happens in practice. It's about the de facto opportunity. That is the obligation that Ukraine has to its citizens. It's also strong language in this convention. As you can see, it talks about guaranteeing the free expression of the will of the electors. Again, this is the obligation that the country has. The other key words that I wanted to draw attention to is that it does make provisions for some limitations on these rights. It talks about reasonable and unreasonable restriction. So then the question is raised of, is it reasonable to limit the voting rights of IDPs? On this subject generally, there are seen as various ways that it can be reasonable to derogate from a treaty obligation. And these are particularly in cases where there is an objective criteria for doing so. Also that it's not discriminatory, it's not targeting one group in particular, that it's proportionate to the issue and the problem, and that it's for a legitimate reason and something that is consistent with what is contained within the human rights treaties. So it could be, for example, that in some circumstances, it might be reasonable to limit participation of some voters in order to maintain the overall integrity of an election. So to maintain that the will of the electors can be guaranteed. So it's not desirable, but in some cases it's recognized that these exceptions need to happen. Another aspect of international law that has implications for IDP participation are the conventions that relate to the participation of vulnerable groups in elections. And as we know, within IDP populations, there is an overrepresentation of women, of people from minority groups, and from people with disabilities. So all of these conventions have particular relevance for IDP populations. So there's conventions on the rights of women, racial groups, and also people with disabilities. All of these conventions have been ratified or acceded to by 160, 170, 180 countries. So they have a great legitimacy and a global authority. I just wanted to give the example from the Convention on the Elimination of All Forms of Discrimination Against Women in terms of elections, just to show the gist of what these treaties say, and again, the relevance for elections. So it says that state parties shall take all appropriate measures to eliminate discrimination against women in the political and public life of the country, and shall ensure to women, on equal terms with men, the right to vote in all elections and referenda, and to be eligible for election to all publicly elected bodies. So what's interesting in this language, I think, is that it talks about eliminating discrimination and ensuring this equality. And what comes out in the authoritative elaboration of these treaties is that this is about equality of outcome in many ways. Are women participating to the same level? And if they are not, then there is an onus on the state to be taking temporary special measures. So as I say, this has particular applicability to IDP populations, given the proportion of vulnerable groups that there are within the IDP population. So again, there is an emphasis on de facto participation, not just theoretical rights, but what really happens. And if that de facto participation isn't there, there is an onus on the state to be taking positive measures of some sort. Overall, this is an area of law that is evolving in many ways. And one example of this is the what's commonly known as the Kampala Convention. It has a longer, more formal title, of the African Union that's particularly on the subject of IDPs. And so far, 25 of the African Union's 40 countries have ratified this, and it includes explicit legal requirements for countries that have acceded or ratified to the treaty to take measures necessary to ensure that IDPs enjoy public participation. So again, there's a practical element to this, not just a theoretical element. Also, the treaty bodies, so for example, to the treaty body for the International Covenant on Civil and Political Rights, in their various commentaries on individual countries, but also their general comments or general recommendations, make a number of points that have particular applicability to IDPs. So, for example, one quote from the UN Human Rights Committee, the treaty body for the International Covenant on Civil and Political Rights, says that states must take effective measures to ensure that all persons entitled to vote are able to exercise that right. So again, it's about effective measures for that opportunity to really be realized. The theory isn't enough. Similarly, it says that positive measures should be taken to overcome specific difficulties. And of course, being displaced from your home location is a specific difficulty. So there's an onus on extra measures in order to get, in some sense, more equality of opportunity and outcome. Moving away from that binding international law onto political agreements, there's more explicit reference to IDP's electoral rights. As many people, of course, are aware, there are the guiding principles on internal displacement endorsed by the UN, which refers explicitly for the right for IDPs to have access to the means necessary to exercise the right to vote and to non-discrimination in that. So this is quite elaborate language to be, again, putting an emphasis on the practical realization. So to have the right to have access to the means necessary to vote. Similarly, it talks about the right to participate fully and equally in public affairs at all levels. So being more particular that it's not just about the national level, but at all levels. As we've heard mentioned earlier, the Council of Europe also has a number of documents and instruments that have referred to electoral rights. So in 2006, the Committee of Ministers referred to member states taking, or should take, all appropriate legal and practical measures to enable internally displaced persons to effectively exercise their right to vote in national, regional and local elections. And later in 2009, the Parliamentary Assembly of the Council of Europe reinforced this by saying that the Committee of Ministers should ensure that IDPs can exercise their right to participate in public affairs at all levels, including their right to vote or stand for election, which may require special measures. So again, it's giving permission for special measures for IDPs that may go above and beyond what the rest of the population enjoys. But always there is this obligation to maintain the overall integrity of the election. Sorry, I forgot to change the slide. Just to pick out a few issues in particular. So as I mentioned, the overall election integrity. there is a potential for special measures to in some way threaten the integrity of the election. For example, as we know, there may be, or many IDPs have difficulties with documentation. They may have had to leave it in their home locations and may not have new documentation. So having lower levels of documentation requirements for IDPs can enable voting, but can weaken their security in the electoral process. So there is a need to try and find a balance, and that's very context specific according to the country in question, and it's a matter of really knowing the detail. There are also, of course, various mitigating measures that can be taken to strengthen overall integrity in an election process, and this includes having more transparency, more scrutiny from observers, having an effective dispute resolution mechanism, so if fraud has, or attempts at fraud have taken place, they can be challenged, and also having a mechanism for enforcement of electoral offences. Another key issue that comes up is residency requirements. So requiring people who want to vote or to stand in a constituency to have to have lived in that constituency for a certain length of time, typically. Well, this is seen overall as a reasonable restriction on who can vote in an election, but of course it can have particular implications for IDPs and can in effect disenfranchise. But interestingly, the authoritative interpretation of the ICCPR, the International Covenant on Civil and Political Rights, states that if residency requirements apply to registration, they must be reasonable and should not be imposed in such a way as to exclude the homeless from the right to vote. And it can be interpreted that in some way IDPs are away from their home and are in some ways homeless. So again, the exact combination in a country needs to be considered. So some of the measures that can be taken to overcome this that I know many people are talking about is how easy, or making it easier for IDPs to transfer their electoral location, their electoral constituency, without there being any consequences to their status, their IDP status. Also, as a result of IDPs being attached to different constituencies, there can be a need to then have a consequent delimitation process as the numbers in different constituencies can change considerably, which is important for equality of the vote, and allowing time, and also another example of good practice and possible measures for this is for IDPs to individually have choice over which location they want to, which constituency they want to be attached to. As I mentioned earlier on the subject of documentation, this is a key safeguard but problematic for many displaced persons. The guiding principles are explicit in saying that IDPs should have access to documentation without returning to their habitual residence. So of course this can have applicability for electoral documentation, that it should be easy for IDPs to get this. This could be through using old measures or through having a fresh voter registration or civil registration process, or in some cases there's been social vouching where several people will attest to somebody's identity and where they are currently living. But it also puts an onus on the need for having voter education so it is clear what process is happening. Just briefly to mention globally, overall I would say there is a lack of data about IDP participation. What we do know from some reports that have come from some countries is that there appears to be generally an underrepresentation of IDPs in electoral processes. And I very briefly wanted to mention one case where I was observing last year in Nigeria, which was a very big sensitive election. And Nigeria has a very big IDP population from the Boko Haram activities with over 1.2 million IDPs. There was a lot of talk about how these people would vote. But ultimately, there was no legislation passed, and there was a lot of push to have legislation, but there was no legislative agreement, which meant there was a great delay in working out how people would vote and put a great burden on the election administration to work out a solution. In theory, IDPs could change their voting location up to 6 weeks before the election, but in practice, there was very little information on this, so this mechanism people weren't really aware of. So in the very last few weeks before election day, alternative locations were set up for people to vote, but only within the state. So people could not vote for their home constituency from another state. So it was very limited what opportunities were given, and there was no information subsequently about the level of participation. So I just mentioned this as an example of how legislative processes could go wrong, in effect, and then it create a sort of bottleneck of decision-making that was needed when the election administration was having to work under very tight time pressure. Then very briefly to mention the case of Georgia, as there are clearly some similarity to here. And in 2001, the law changed for IDPs to be allowed to vote in local elections. And 2 years later, for them to vote in majoritarian elections, in parliamentary elections. Prior to that, if they had changed their registration, it would have meant a loss of IDP status. So in effect, IDPs weren't really being given the chance to participate until there was that change in legislation. These changes followed some comments from the Council of Europe and also the OSCE observation missions, who commented that without IDPs having that full opportunity to vote in local elections and in the majoritarian part of the parliamentary elections, electoral equality was profoundly undermined, essentially. In terms of development of policies and laws related to the participation of vulnerable groups, including IDPs, some of the good practice that has emerged is that it be evidence-based, so to try and have as much disaggregated data as possible about the numbers of IDPs, the locations, and whether they are participating, so that then decisions on policies can be based on substance rather than just talk. Also that there be consultations, particularly with groups broadly representative of IDPs, but also the elected administration, given the practical implications and challenges there are of implementing voting for displaced people, and also civil society. As far as possible, having consensus-based decisions, essentially giving the opportunity for IDPs to vote changes the electorate in some way, and so means there can be a change in electoral outcomes. Anytime that happens, it's highly politically sensitive. So the need to have political consensus where possible, and also to do it well in advance of the election, as anything closer to election becomes more heated. And then finally, just to say with reference, there should be reference, of course, to the international obligations that a country has. So finally, just to mention in the case of the Ukraine, as we know, IDPs here can't vote using the majoritarian ballot. So there's, again, this profound inequality of citizens' voting ability, and can't vote at all in local elections. So this is not consistent with Ukraine's international law commitments, and it's very large numbers of people who are affected. This also risks government being less accountable and IDPs' overall rights being less fulfilled, and increases the risk of marginalisation. Sorry, I've talked for a long time. Thank you for your patience, and with that, I'll pass the floor to Sean.
Thanks. Thanks, Hannah. Thanks a lot. And please, Sean Loughner, please.
Good morning, everyone. I've been asked to talk about the international context of internal displacement a little bit. And I'm not going to discuss elections per se, but provide you with a few statistics around trends in displacement, and then identify a couple of thematic trends which I think are important and Ukraine might consider looking at in terms of developing legislation and a strategy. And finally, emphasize, I think, the importance for a holistic approach in developing the state strategy beyond just political rights. So, first of all, according to the latest statistics from the Internal Displacement Monitoring Center in Geneva, there are currently over 40 million displaced people in the world today, residing in 127 countries. So this is a global phenomenon. It's the highest level ever currently. There are twice as many IDPs as there are refugees now, and this again has been a trend really since the early 2000s, where the number of refugees has relatively diminished. That's changed with Syria to a large extent, but prior to that, it's been more difficult for people to seek asylum and gain protection in another country. And for various reasons, they become, therefore, internally displaced. In the past, during 2015, which is the last year for which we have full figures, 8.6 million people were newly displaced in 28 countries. Over 50% of these were in just 3 countries, Yemen, Syria and Iraq. But it's worth noting that in the top 10 countries, Ukraine now appears. So it is in the top 10 countries of internally displaced people in the world. Now, as has been mentioned by Mr. Nemiri, I think what we see in these displacement situations is a phenomenon of protracted displacement, long-term displaced, which, as he said, the UNHCR before us and others have defined as being more than 5 years. We're seeing a lot longer periods of time of displacement than that, which has implications, I think, for how we address, how we develop policies and responses. And it is, therefore, a development issue in a large way, beyond the humanitarian into much more issues around sustainable development and resilience and self-reliance. And in terms of displacement, resolving displacement issues, so-called durable solutions, the 3 durable solutions, people integrating where they are, moving to another place or returning to where they came from, there are huge challenges in most of these displacement situations where a durable solution, where people feel self-integrated, where they feel they've restored their livelihood to an equivocal level to before their displacement, is increasingly apparently difficult to achieve. So I think in this context it's also worth remembering that in recent years we've seen, I think, a reduction in the international attention that internal displacement gets, as it's competing with particularly the Syrian refugee crisis and others from Iraq and Afghanistan moving westwards into particularly the European Union area and its great concern with onward migration. I think there's been a lot of media focus on that and much less on countries like Ukraine with these more newly displaced phenomena. And that's also related to, of course, the nature of the conflict in Ukraine being more of a simmering conflict, although a hot conflict, a simmering one as opposed to, as we see in Syria. I think it's, when we look at protracted displacement situations, I think I know we hear a lot about Georgia, but there are a lot of similarities whereby I think it's worth examining Georgia a little bit and seeing what we can learn from the case of Georgia. The initial displacement was in the early 2000s, so the majority of those that are still classified as displaced were displaced 25 years ago. 50,000 of them still are waiting for a durable housing solution following the 2008 conflict with Russia, whereby prior to that I think that Tbilisi was somewhat detached from the conflict in Abkhazia to do with displacement from Abkhazia, even though they were, many of them, in the capital city. I think 2008 really shook the nation, whereby they realized this could affect Tbilisi. We could be invaded here. And attitudes very much changed then, and I think became much more supportive of IDPs and trying to find durable solutions. So since then what we've seen is this movement towards finding durable housing solutions and finally linking livelihoods to resolving the the situation of IDPs. And this is, I think, very important, therefore, what I'm trying to say is not wait 20 years, but realize that displacement's likely to be very protracted. It's likely to impoverish lots of people. And we therefore need a state strategy at an early stage which addresses a lot of these concerns at an early stage and looks at wider economic issues as well as the political ones, because eventually these IDPs will have the right to vote. That is going to happen. And when they do, they're a powerful political constituency. So it's very important, I think, to ensure that they have this economic, social and civil rights as well, that we take this kind of holistic approach in providing all of their entitlements. I think I'm going to leave it at that for now, actually.
Дякую, Sean. Thank you very much. Thank you. Thank you, Sean. Erin Mooney, please. Thank you.
Good morning. Thank you to the organizers for allowing me to join in this discussion. And I really want to commend them for organizing a conference focusing on this issue of IDP political rights, not least to have an entire day focused on this issue. It's something that IFES, I know, has worked on in a number of countries, and it's very timely to be doing so in Ukraine as well. The question does often arise, well, what is the urgency of focusing on IDPs' political rights? Surely it's more important to address their economic, social rights, such as their urgent need for food, shelter, livelihoods, and employment. And of course, those humanitarian and resilience and livelihood needs are tremendously important and need to be addressed in an urgent manner. But I would argue as well that the political rights are just as important to address in a timely manner. Certainly this is the right of internally displaced persons. Unlike refugees, they remain within their country and therefore remain entitled to their full rights as citizens or habitual residents. And without addressing their political rights, we're really disenfranchising them from having a voice and a vote, quite literally, in the decisions that impact their daily lives and in the programs that will help to address their humanitarian and resilience needs. And so it's absolutely critical to be addressing these issues as soon as possible and not look at things in a hierarchy of approaches. The Constitution of Ukraine, of course, guarantees this right for all of its citizens in Articles 69 to 71. And IDPs do not lose this right because they've been displaced. This is reconfirmed in the international standards, which Hannah very helpfully has summarized, whether that be the guiding principles on internal displacement or international covenants, both of which Ukraine has committed itself to implement. Also at the regional level, commitments of the Council of Europe, as Hannah has mentioned, as well as the OSCE, again, commitments to which the government of Ukraine has committed itself to observe. And so it's very clear in terms of the normative framework that IDPs have a right. But in practice, what we see around the world is that there are a number of practical impediments to IDPs enjoying this right. And this is not an issue unique to Ukraine. It tends to come up in literally every IDP situation. There are a number of practical obstacles. Hannah has mentioned a number of them, such as documentation, which is often very much lost in the course of displacement and needs to be replaced. So there need to be facilitated measures for that. But really fundamentally, one of the key challenges is that typically voting rights, particularly for parliamentary majoritarian or local elections, are very much tied to residence. Your residency, your place of residence. That's the same in my country of Canada. I need to prove that I'm a resident of a particular electoral constituency in order to have my vote count there. And because displacement by definition means a sudden and involuntary change of residence, this really complicates the issue as well and raises questions about where should IDPs be able to cast their vote. And the international guidance on this is really quite clear, which is that IDPs maintain their right to vote, and they should be able to exercise that vote and have that vote count either in their place of origin, their pre-displacement area of residence, or where they are currently staying. So there's a choice between where and in which electoral constituency IDPs would prefer to register, and that's a choice that should be available at the individual level for IDPs to make. The case of Georgia has been mentioned and summarized quite well. It is quite analogous to here in terms of the challenges of voting in parliamentary elections, that IDPs were told in Georgia at the time, well, your representatives in parliament from your area of origin will maintain their mandate and speak for you. Now that might work for the first year or 2 years of displacement, but IDPs were expected to accept that these parliamentarians' mandate would continue in perpetuity which of course doesn't allow any of those sort of democratic levers of influence to also choose your electoral representative. So clearly that needed to be adjusted after a decade of people not having their mandate renewed. And at the local elections, as Hannah has mentioned as well, IDPs were told that if they registered, they could register in the area where they were living while displaced, but to do so, they would lose their IDP status and the benefits that entitled them to. So of course, that was not a decision IDPs would take lightly. In addition, there was really a lot of misinformation. IDPs were also told, if you register locally, you will lose your right to return, you will lose your right to property. I mean, legally, of course, this made no sense, but the point I'm trying to emphasize here is that these issues often are highly politicized, and IDPs can be manipulated for political purposes, and misinformation and inaccurate information can be channeled to them that has a tremendous impact on their rights. The case of Georgia is interesting as well because what instituted the legislative reform, first and foremost, was a domestic effort. IDPs lodged a case with the Constitutional Court that this was a violation of their rights under national legislation. These efforts were then amplified by international voices at the UN and the Human Rights Committee, at the OSCE and the Council of Europe and so forth. So it's an interesting case in terms of international and local advocacy teaming up to change the rights of IDPs. As Hannah has mentioned, it did result in a reform of the legislation, of the electoral code of Georgia, both for elections at the local level and parliamentary level. And I want to emphasize here that the numbers of IDPs we were talking about in this particular case that mobilized such international and local attention was a sixth of the number of IDPs that are registered and reported to be in existence in Ukraine today. So one can imagine if the case was very compelling in Georgia for really a sixth of the population of IDPs, that could be amplified in this sort of context. So what does all this mean for Ukraine? I think there are really four key areas where action is needed on this issue. The first, a study that I've done with local lawyers here in Ukraine pointed to the need for changes to the system of IDPs being on the electoral list. There are special provisions under Ukrainian legislation for persons that are serving in the military or even people that are in prison to have, there's an exchange of lists that would facilitate IDPs from the IDP registry automatically being put on the voters list. So that's almost a sort of technical issue that would make it more efficient. But the key issue rather is legislative reform. And that's on two levels. The IDP law, it's very positive that Ukraine is one of the relatively small number of countries in the world that has taken the step to adopt IDP legislation. This is one of the benchmarks of national responsibility. The government is to be commended for that. An area of amendment of the current law would be to Article 8, which does limit IDPs' right to vote only in their area of origin, to have their vote count there. And of course, what are the measures to do so? There would need to be absentee voting rights, but there does need to be the option, again, to be in compliance with international standards that IDPs can vote in their current place of living. Secondly, of course, it's not sufficient just to change the IDP law. Experience around the world has shown one also has to look at the companion legislation. Here would be the electoral legislation and ultimately an electoral code. Should that come to pass, but the series of laws that exist nationally. The third step is a point that Hannah has mentioned as well, a bit about information. Again, in a number of countries that we've looked at, one of the challenges has been that even if you have legislative reform on these issues and the procedures are perfect and in compliance, they're often very poorly known. First and foremost by the electoral officials that need to implement them, and this leads often to contradictions and them not applying laws. It can often be done in a very quick manner, so I think the point about doing this well in advance is very important advice that's been given. But there needs to be training of electoral officials on the very specific provisions that will be introduced for internally displaced persons to avoid confusion and potentially even abuse at the polling stations. And information also needs to be extended to internally displaced persons about their voting rights. Again, bearing in mind examples of misinformation, I would suggest this is really an important role for civil society and for independent observers or communicators such as the Office of the Ombudsperson to make sure that there's timely and objective information to safeguard against any sort of political or politicization of the issue. And then the fourth and final point is the importance of monitoring. Again, I would stress here that having the laws on the books, having information to IDPs, again, these are all important measures, but when an election does occur, there needs to be very clear and close attention to this specific issue for here more than 1.7 million potentially people of voting age. And that would be a important role for civil society, the Ombudsperson's office, for also international observers. The OSCE increasingly is looking at IDP voting rights and should be doing that systematically. And so finally, just to say that IDPs, of course, are citizens. They have the right to vote, that they do not lose that because of displacement. They need to be able to have the choice as to where their vote counts, and that a responsible government is one that ensures that IDPs can have a voice in the decisions that affect their lives.
Erin, thank you very much. І якщо ви маєте якісь короткі запитання, прошу до наших експертів. Так, прошу.
Чому коротке?
Можете довге запитання.
My name is Sergey Nagorny. I'm from Ukraine. Study topic which we listen from the international expert about Iraq, Syria, and other MENA countries. My postgraduate study deal with in Koreyский Institute. First scientific work deal with policy and legal process in the MENA countries. And my question, are you agree with me that today we have Iraq, Ukrainian Iraq in our territory? I mean Lugansk and other. Because you speak about Algeria and other interesting Arabic country like Iraq and Syria, because there are very young civil society and democracy too, like Ukraine. And I hope that you agree with me that we haven't Ukrainian Afghanistan in future. Thank you.
Thanks. Yes, please, Hannah, you want to answer?
Nothing specific to add, but just to emphasize again what I think you were saying and also Erin was saying about the important role of civil society and IDPs leading in this process and being involved. So people who may not have been used to being involved in civil activism, that it's really an opportune time for doing this.
Thank you. Erin, Sean?